there's so much at stake. This man's life now will be in the hands of this jury, the same jury that found him guilty late last night. Let's talk briefly about this before we hit a break and get you into the courtroom. John Mobley is with us. He was with us last hour. He's in Colombia, South Carolina, and here in studio, the Daryl Cohen. John, this decision is a very difficult one, and we've seen it time and time again where death-qualified jurors, people that say, yes, I could enact the death penalty if warranted, have a tough time pulling the trigger when they're actually seated on a case like this and they have another individual's, in this case, another man's life in their hands. Talk about how we may be sitting at home thinking, oh, gosh, this is for sure slam dunk death penalty. The guy stabbed a little boy. It's not so easy, is it, for jurors?
Well, I got to tell you, Ted, I got to call it like I see it. I think that if the jurors are of the mind frame that they can actually give someone the death penalty, the facts of this case are going to make it such that they're probably inclined to do it. I mean, the visual of this man lying in wait for his mother and his 3-year-old son and coming out of the bushes and violently, horrifically stabbing them to death in that manner is something that jurors are not going to be able to get out of their minds. There's no doubt about that. So while it's never a slam dunk, you don't ever take it for granted that they're going to give the death penalty. This is a case where I think if they're inclined to give it, they've got a lot of reasons to do it. They're going to see this guy as a monster. They're going to be asking themselves what kind of person can do this, and they're going to be having a hard time to find any reason to show compassion to him in this phase of the trial. His lawyers have an uphill battle. They've got to show the jury this man is not a monster.
Yeah, absolutely.
I really think, and I really believe he needs the first witness needs to be the defendant. He needs to get on that witness stand and look at that jury and accept full responsibility for what he did. He needs to show remorse. He needs to tell the jury how he sees his son's face in his dreams every night and how every day just psychologically a nightmare for him. I mean, they need to hear that from him. They need to, he needs to give them a reason not to put him to death.
What's your opinion of that decision last night by the judge when the jury said, can we just please come back tomorrow? And he said no.
I'm actually kind of surprised by that. Obviously, judges have broad discretion regarding how they manage their courtrooms during trial. But typically, it's been my experience that judges typically like to defer to jurors when they say they need a break or need, some type of, space between different phases of the trial, whether it's bathroom breaks, whether we just need a break to stretch our legs. I mean, this is a very emotionally exhausting and draining trial to hear about, all these graphic details. So it's completely understandable that at the conclusion of all of that and the effort they put into rendering their verdict, the jurors saying, hey, we just need a break. This has been very emotional, it's been very graphic. We understand there's a second phase. Let us go home and unwind and get some sleep and come back fresh. So I'm very surprised the judge didn't think that was reasonable, because I think it is reasonable. Now, whether or not that's going to be a legitimate ground for appeal, I mean, obviously they're going to use it as a ground, but whether it's going to be something where an appellate court deems it as a reversible error, I highly doubt it. Unless the jurors just say, hey, we can't make a decision, we can't be fair without a break, we can't fully understand and comprehend the evidence. They would need to say something like that in order for it to be considered reversible.